Today I have a great pleasure of chairing this panel that is talking about consent and the role of individual control in the ever-changing world of data protection and data privacy. And you know, I've been doing data privacy protection for over 20 years, and 20-something years ago we were talking about cross-border data flows, and today we are talking about that again. And we talked about consent 20-odd years ago, is it opt-in and opt-out? But today we are talking about it again, so it's really either worrying or really strange that we are here 20 years later. Why are we here? And why did we pick up this topic to talk to you about? I have a stellar panel that I'm going to introduce very briefly, but let me just make some opening remarks. As a chair, I've got the prerogative to do so. Of course, data privacy, data protection is all about people. It is all about responsible use of people's information so that they don't suffer damage and any type of harm. Individual is always the focus of data privacy, data protection. We keep hearing that all the time from regulators, and indeed, many privacy laws take that view as well. And therefore, consent is a central element of many privacy laws today. It is so in Europe, and it is also having a central and important role to play in the revised data protection or proposed EU data protection regulation. Indeed, last week, and in fact later this month, DAPIC's working party is going to be talking about the exact consent and what that should look like under the new regulation. In the US, notice and choice are one of major privacy principles, FIPS, and we have got a very rich experience coming from there as to what that looks like and what the expectations of regulators are. In the many emerging roles of Asia, Latin America, in mature economies such as Japan, Japan is also looking at the role of consent in their data privacy law and thinking what should that be in this modern information age. So it is central, it is important. However, the second point I'd like to make is that we keep hearing also, and we keep hearing all the time, if you read the Japan policy document, and I know Professor Hiroshi is here, he can tell us, there we are, you know, they talk very beautifully about this growing gray zone where organizations are not sure if they can or not use data, what consent or not they should obtain, and that actually impedes potentially data-driven economy. We keep hearing debates on both sides of Atlantic, and Atlantic is the important, and I apologize for those of you who are not in the US and EU, but there are lots of debates about how do we need to implement the role of notice and choice, the principle of lawfulness, consent or something else, in the world of big data, in the world of Internet of Things. And you only have to read Article 29 opinion on Internet of Things, where they really question and wonder what that consent is going to look like, and is it going to be freely given, specific, is it going to be also informed? And of course, you only have to visit Washington and go to the excellent workshops that FTC runs on a number of topics, and they've done one on Internet of Things, where again, this was very much debated. So how does the consent look like in this new world of big data, Internet of Things, when we have consistent and constant data collection, data use, data sharing? And I have to read to you a very short quote that I have actually just found out. It forms part of the PwC report on wearables that they published in 2014. And one of the senior executives of Airbnb, I think you all know Airbnb, and they're a great company, he says the following: in the distant future, we will forget the idea of engaging in technology at all. We will swallow it, we will absorb it, and wear it, without us really thinking we are engaging in technology per se. So I'd like us to think, what is the need to obtain consent going to look like, where it's going to be completely pervasive? The third point I'd like to make very briefly is that, of course, we live in a paradox where consent practices are really questioning today the validity of that consent. And I'm not going to make any jokes about any companies in the length of their privacy policy and Shakespeare plays, because we've heard that before. But we are facing long legalistic privacy notices, carte blanche, sweeping consents that frankly are probably legally overarching. They just have never been challenged in any courts, but they certainly may never really protect individuals, but they may give ability to organizations to do as much as they can. Now, is that the way we would like to go? And that's a question that we are going to be asking here. So consent as a term of use, consent as a panacea for all, consent at the time of collection that then justifies everything you want to do 20 years later, that's a big question. And I remember very well in my times leading privacy in a major global organization when I used to discuss some subsequent uses of data, and people said to me, but we obtained consent when they joined us, when we employed them. They signed the consent form, therefore we can do it. Well, that's not the way we have to look at these things at all anymore. The fourth point, an important point, is we have started to over-rely on consent. Not only have they become too long, too legalistic, but we are over-relying on consent where we don't need to obtain consent and where there are other legitimate grounds for processing. And I have to praise, in fact, the legal regime that we have in Europe, because consent, although everybody talks about it as being central, we have a number of legal grounds under which we can process data. And processing, just to remind everybody, means collection, sharing, disclosing, destroying, transferring, using it for purposes compatible or perhaps not as well. So necessity for the contract, legitimate interest, these are all grounds for processing that organizations have been very timid to use, and they've been over-relying on consents and adding to the problem that we have of these long, everlasting, and perhaps not valid consents. And then my final point before I ask my panelists to talk to you is really, I think we need to find the balance between the control of individual, the focus on individual, that may not mean consent, and the responsibility of organizations to use data responsibly, accountably, to be responsible for the way they use their data rather than obtaining carte blanche for what they want to do. So I will just remind everybody that in a very mature legal regime that many privacy laws around the world know today, we do have a number of other elements that bring control to individual, such as transparency and notice, telling people what we are doing. Whether that's done correctly, that's a separate, but it exists. Legitimate interest and other legitimate grounds in European law. We have right to object. We have right to block, erase, right to correction. We have got enforcement and complaints by data subjects, individuals, but also by data protection authorities. So all of this, I would say, helps keep user in control rather than just relying on consent. So with that, I'm going to very briefly introduce the panel. We have a great mix of regulators, practitioners, and of course industry, privacy advocates or consumer organizations. The first panelist is going to be Julie Brill, the Commissioner of the Federal Trade Commission. Then we are going to pass on to Wojciech Wiewiórowski, who was ex-Poland Data Protection Authority, but of course he is now the Deputy European Data Protection Supervisor, new in his role. Then I'm going to ask Marie-Charlotte Roques-Bonnet to speak about Microsoft's position on consent and best practices. And then Finn is going to give us perspective of the consumer organizations. And Tine Larsen, who is also data protection regulator, head of Luxembourg Data Protection Commission, will be moderating a short discussion among the panelists, and then we're going to open questions to you. So with that, Julie, will you please kick us off?
I would be happy to. Which microphone should I use? Okay, sure. Hello, everyone. Good afternoon. I'm Julie Brill. I'm one of the commissioners of the U.S. Federal Trade Commission. For those of you who may not know about the FTC, and I'm hoping many of you do, if not everyone does, but I don't want to presume. So, you know, the Federal Trade Commission is a bipartisan independent agency. We are the nation's, the United States' leading consumer protection agency, one of two leading competition enforcement agencies, and then we are also, within our consumer protection remit, we focus on privacy and data protection. And we do so largely through law enforcement, but also through policy development and working on best practices. So, I'm happy to chat with any of you afterwards about what the FTC does. We are really rocking when it comes to privacy and data protection. And in fact, many of you may know that the president chose our agency to come to 10 days ago to announce his forthcoming initiatives on privacy and data protection, which he then echoed in a much briefer form last night in the State of the Union address. So we were really proud to host him, and it was a really exciting moment for privacy in the United States and also for the FTC. Okay, consent. Look, consent is an incredibly important element of the FIPS. Consent plays many, many roles within a privacy regime. It's not just about individual control. When you think about the role that having a privacy policy plays with respect to, from a company's perspective, if a company is forced to put down what their practices are with respect to data, what they're going to do with it, the life cycle of the data from their perspective, that is a very good thing. So requiring companies to have a privacy policy forces them, and I'm not just talking about the very big companies that make it in the news all the time, but there's an extremely long tail of actors in the mobile space when it comes to apps, when it comes to lots of other types of providers. It's very important that they are cataloging in their own minds, what is it that we're doing with data? What do we want to say that we're doing with our data? We have to disclose what we're doing. Does this make sense? The privacy policy plays an organizing role with respect to their practices. So I, for one, although I think we absolutely need to modernize the way we do consent, the way we do notice, and I'll talk about that in a moment, I don't want to do away with privacy policies because I think they play a very important role for other purposes. But consent has had its challenges. While I think it's critical for individuals to have control, let's look at what's happening now when it comes to the Internet of Things. Bojana was talking about that a moment ago, where there are going to be billions and billions of sensors, more sensors than there will be computers. And these sensors are going to be collecting not just sort of aggregated data, but also deeply personal information about our health, about when we're home, about our energy uses, and about where we're going on a day-to-day basis. It is incredibly important that we think about the role of notice and choice in a world where there are ubiquitous sensors. And many of the devices that are going to become connected aren't going to have user interfaces. Consumers may not even realize that some of the devices are connected. So we need to be thinking much more creatively about how to engage consumers in terms of the types of controls that they can have in a sensor ubiquitous world. But even before we get there, and this world is actually starting. I don't want to make it sound like it's years away. I just came back from the Las Vegas Consumer Electronics Show, and the Internet of Things is everywhere when it comes to consumer electronics. But even when you're talking about mobile devices, which are collecting one of the most sensitive types of personal information, which is geo, and how geolocation information is being collected and used and shared, even this has had its challenges because you're talking about a device that has very little room for effective notice and choice. And then there's the world of third-party data collectors, data brokers, ad networks, and other entities that are analyzing information and cataloging all of us in terms of our preferences, our desires, what kind of, sometimes for fairly benign purposes, like what kind of ads we may want to be served, but sometimes for more substantive purposes. And the world of data brokers also challenges this world of notice and choice because most consumers have no idea who data brokers are, let alone being able to go to their website and making choices about how their information ought to be used for marketing purposes or for other purposes. So one of the things that I also want to mention in these brief opening remarks is that at the FTC, we have brought numerous cases against companies when they have been deceptive or unfair about their disclosures, their notices to consumers about their data collection and use practices. So some of these cases involve things like failing to disclose the full breadth of the information that's being collected, giving consumers a little bit of information, but not telling them sort of the deeply personal information that's being collected and used. We brought a case against Google for populating a social network with consumers' contacts when consumers were not necessarily choosing to have that done. Automatic downloading of contacts, automatic collection of geolocation, material retroactive changes in data collection. We have brought cases against all of these practices, both with respect to very large companies that are household names and with respect to much smaller companies that you may never have heard of. So what does this mean for consent and for notice to consumers so that they can make effective consent? I think in this world of ubiquitous sensors, of the Internet of Things, even with respect to mobile, we need to be much more creative about how we're providing notice and consent to consumers. We need to use just-in-time notices. We need to use short, layered notices. And the FTC talked about this in our 2012 privacy report, that we need to bring some of the modern age of the Internet and the way in which people are being communicated with. We need to bring those concepts to notice and choice to make it more effective. But but notice and choice needs to be part of a world where we're focused also on things like privacy by design and data minimization, so that consumers don't have to make choices about every single little thing. That is, we need to be building more protections under the hood at the same time that we're building more effective dashboards for consumers. So I think the notice and choice conversation can't be separated from the other better practices that we think companies need to be engaged in so that consumers don't have to be faced with this bombardment of choices over everything that they're doing. And that brought us at the FTC to this concept, which we didn't invent. Helen Nissenbaum at NYU was actually, I believe, the first person who talked about focusing on the context of the transaction. So that consumers, if you're dealing with a data use, data collection, that's part of the context of the transaction, that would be fully expected by the consumer. We don't need to bombard consumers with notice and choice in that context. But when you're focused on uses of data that is outside the context of the transaction, onward transfer that would not be expected by the consumer, that's where notice and choice ought to kick in. And how should this notice and choice be done? When we're talking about the Internet of Things, when we're talking about sensors, think about immersive apps or websites or places consumers can go so that they're not just learning through legalese or through words how their data is being collected and used, but show consumers in pictures and icons and in a very immersive way what's happening with their data. These are some of the recommendations that we have been making. I have called for the data broker industry and other third-party players to engage in this as well, to provide a single portal where consumers can go. One place where they can find out who are the major data brokers, what kind of information do they have about consumers. When consumers have choices, give them the choices right there in this portal. This is an initiative that I've called Reclaim Your Name. So there's a lot, in my view, that can be done to modernize notice and choice, to make it more effective for this age of the Internet of Things and ubiquitous collecting. But I also think that we need to make the notice and choice regime part of a broader regime that also focuses on privacy by design, data minimization, appropriate retention and deletion practices, and all the other FIPS, so that we're not just thinking about notice and choice standing alone. So thanks very much.
Thank you for being on time, Julie. And we pass the word to Wojciech.
Thank you very much. Wojciech Wiewiórowski, Deputy European Data Protection Supervisor. It's hard to say something after the conclusion that was already done by Bojana, who's shown what shall be actually the result of the discussion today. Well, moreover, I'm not going to say too much new. I'm actually going to say about the things that you know precisely, that you read precisely many times. But I would like to renew them somehow and show you the perspective that was important for the European Data Protection Supervisor last few years. Well, is the consent in the middle and in the center of the discussion about the legal grounds for data processing. And Bojana has already said that from the European perspective, consent is important, but it's actually only one of the legal grounds that can be taken into consideration. And it's like that according to the directive from '95, but it's also like that in all the proposals that were given as far as the new regulation is concerned, and actually the future of the European standard. There was always the discussion what kind of grounds we have to recognize in Europe, and all these grounds that are at the moment on the table appear already in the directive from 1995, and they appear also in the Parliament text on the new regulation for the future. And consent is only one of them. It's the one which is on the first place, but it does not say that it is the queen or king of any kind of legal grounds that we may have. The performance of contract, legal obligation, vital interest of the data subject, public interest in, or a exercise of official authority, and of course the legitimate interest. And I'm going to, in this short intervention, to say mainly about legitimate interest, since that was the part of the discussion that was done in the group of Article 29 last few years, and that was the discussion which was chaired by the former European Data Protection Supervisor, Peter Hastings, because the European approach to what means legitimate interest was extremely important after several years of the directive being in force. Because while in some countries we had the problems to find any kind of regulation in the national law about the real legitimate interest, in some other countries the law about legitimate interest was quite broad. So despite the fact that the directive has already said about it, we had the problems with implementing this directive in some national laws, like for example the Spanish law, even a few years ago. And after that, the group of Article 29 decided to discuss about some problems with the legal grounds that we had so far. With the consent, and you know that there was an opinion about the consent, and legitimate interest. If we think about the new way of thinking about consent in the new regulation, I would like to show that the proposals that were given so far, and especially the Parliament text, which I believe will be the basis for the further discussions on consent, even if the Council is going to discuss it in the nearest future, this text does not differ too much from what we had from 1995, but at the same time, it envisages the different innovative approaches to consent that Julie Brill was talking about a while ago. The data subject consent means any freely given, specific, informed, and explicit, that's of course the thing which is under discussion, indication of his or her wishes by which the data subject, either by a statement or by clear affirmative action, signifies agreement to personal data relating to them being processed. That's what is in the parliamentary text, and which I believe will be the basis for the further discussion. And legitimate interest do not look that much different from what it was so far, but it also discusses in the text of the new regulation some of the concerns which come from the group of Article 29 opinion. And of course, the part which is to be discussed at the other meeting is the problem: should it be only the legitimate interest of the controller, or also the third party to whom the data is disclosed, which is the part of the discussion about the new regulation, but I guess this is not the place to discuss about it right now. What is said precisely in the opinion of the group of Article 29 and also in the draft regulation as it was prepared by the Parliament is that there are some tests that have to be passed if you want to see that legitimate interest is actually the basis for our activity. And the test, one of the tests, is of course what is the legitimate interest towards the fundamental rights and freedom of the data subject. But the group of Article 29, when it started to discuss about legitimate interest in the opinion, quite a long opinion, but I really want to encourage you to read it and to get to it. The group of Article 29 has said that it recognizes the significance and usefulness of the article about legitimate interest criterion, which is the rights, which in the right circumstances and subject to adequate safeguards may help to prevent over-reliance of the other legal grounds. And it has to be understood as showing that this is as good legal ground for processing the data as the other ones that were mentioned, including the consent. And apart from that, the group, and later on also in the draft decision, it has been said that we have to remember about three main points: the nature and the source of the legitimate interest, the reasonable expectations of those who are actually the subjects of the data which is processed, and then the additional safeguards which could limit undue impact on the data subject. The group of Article 29 also recommended implementing in the recital of the proposed regulation the key factors to consider when you apply this balancing test, but actually no universal balancing test has been presented so far. I will skip this one, and I will go to the final thing. The notion of the legitimate interest has to be individualized in the action of all controllers. There were so far the situations in some national laws where there were the examples of the actions which are done under the under the legitimate interest, which were presented in the national laws. The group of Article 29, in its opinion, which, as I said, the EDPS was playing quite an important role in drafting it, has set the list of non-exhaustive list of some of the most common contexts in which the issue of the legitimate interest may arise. And this list is there. There is also the number of the examples where the legitimate interest can be used. So remembering that the consent is one of the main legal grounds that we use, and absolutely agreeing with Julie with this innovative approach to consent in the nearest future, especially when the Internet of Things is concerned, especially when the mobile apps are concerned, but also in the situations where you don't even think that you gave the consent to process your data. I would like to stress the importance of the legitimate interest as one of the grounds for processing the data. Why I'm saying that this is not only Internet of Things, this is not only the problem of the mobile applications. The best example, which I may give, where we gave a kind of consent, but we don't know actually for what, is the smart TV set. If you have a smart TV in your house, you probably are not aware of the fact that you gave the consent for your data to be transmitted to South Korea, to some Arabic countries, maybe even to Russia, who are the producers of the TV. That was one of the things that you agreed with when you set the smart TV. And how does it come? With the consent from the European perspective. How it also come with the European laws on transboundary flow of data. Thank you.
Thank you, Wojciech. Okay, we have the swapping of the places. Marie-Charlotte. And thank you, everybody, for keeping the time, because you're giving more time to the audience.
Thank you. So I would like to share with you a journey, a 12 minutes one, the one of a data controller that would be accountable, and the one of a data controller that would not take a consent, prior consent, as a waiver. And lastly, a data controller that would like to build a trustworthy relation, a long-run relation with data subjects. So the panel stress out the fact that prior consent might be the issue, but maybe not. So let's state it clearly from the beginning. The fact that we ask for prior consent is the basic stone. It's not dodging consent that is the key of our discussion today. And I would like to stress it out really clearly. What is the key of the discussion, and maybe one of the interests that we pay attention to because this is crucial, is that there is a difference between theory, being, for instance, reading all documents as if being an international lawyer at work, and you, me, consumers at home on Sunday night in rush, having to access a service online that no competitor could provide, and then clicking yes. And this is prior consent in real life. You won't see that much on this graph, but I wanted to share with you because at least at the corner here, on the right side, you will see that privacy among all the concerns that people would have towards personal technology. They would say, yeah, it's a way to find lower price goods. Yes, it's good for innovation in businesses. Yes, it provides better education, but the problem is privacy is at stake. So this is a survey that was done by Microsoft and released 2 days ago for Davos Summit, and it really states clearly that developing and developed countries reach the same conclusion, which is really scarce, only on privacy issues linked to innovation. So I wanted to go for 3 questions. One will be really the introduction. The 5th one would be Microsoft position really shortly. 2, 3, and 4 would be to stress out some key points. I think I'm going to try to go really quickly on the first one. So as working for years for the CNIL, French DPA, I couldn't resist, stressing out the 5 pillars of consent as indicated in the opinion released by Working Party 29 on July 2011. That is to say, an informed consent, unambiguous, explicit, specific, and freely given. So if I try to sum it up, informed and specific and freely given would be in the definition of consent itself, as really stated in Article 2H of the Directive. And then you would have some additional possibility to qualify consent. It would be unambiguous, that is stated in Article 7A. Prior, you wouldn't find it. You would find it in the e-privacy directive 4 or 5 times on, spamming and other issues. But prior is kind of an implicit concept stemming from all the other qualifications. So now is coming up another reflection with the draft regulation. What about not envisaging consent as a punctual, prior way to inform data subjects and get the prior agreement from their part, but being, just the basic, the cornerstone, but only the first step taken. And then we could go to the right to withdrawal, which is really indicated clearly in Article 7A of the draft regulation. And for copy-pasting, why not? The lifecycle data protection management that normally targets data controllers, but that could also give some kind of dashboards, some control tools to data subjects. Here I'm going to skip those slides because they were about, stressing out what was already in text. But we obviously with Wojciech went through that. Maybe one remark on this one: explicit is only, in the directive indicated for special categories of data. Consent in itself, the way it is defined, does not state explicit. Explicit, on the contrary, is used to identify clearly, specified, explicit, and legitimate purposes. So there is a confusion. Explicit, yes, applies, but for special categories of data only. Unambiguous and specific, as I said, the difference would be that unambiguous, as it is really framed in the Article 7 of the directive, is about individuals' intention to provide consent. So this intention should be beyond any doubt. Then freely given, I wanted, maybe to have a focus on this one. Recital 34 of the draft regulation, the Council version released by Italian presidency on December last year. I just go through this one. In order to safeguard that consent has been freely given, consent should not provide a valid legal ground for the processing of personal data in a specific case where there is a clear imbalance between the data subject and the controller. So let's brainstorm together. Is there going to be a situation in which there won't be that clear imbalance? This is a question we should, regard today together. Then prior, as I said, it stems from e-privacy directive. Second question, let's get to reality, to this real world in which you've got to consent. So I am a data subject, sure, but I am a consumer. I want to access a service, for instance, online, and I'm going to think, okay, I've got some problems, I'm going to check some issues. So I'm going to think about terms and conditions, maybe a privacy statement, and I'm going to try to find out a solution or information about data location, sub-processing chain, unilateral modification. And then, it's just for fun that I made this slide, but then I discover online that terms and conditions are in different languages, and that most often English one would prevail. Then there are several privacy statements. Then there are appendixes, model clauses, ad hoc clauses, code of conduct, supplementary documents. So instead of 13 hours reading as a lawyer, I'm going to need 2 hours more. And then if I want to dig into a matter, 1.5 hours more. And then it goes this way. I won't find maybe the information I was looking for. I was told that something was not so important, so what about it? So gathering information and reading it really becomes a real challenge. Mapping blocking points is also what we are supposed to do, because reading those documents is for us to know whether we want to consent or not. So commercial photo use, public security, data transfers, rights, portability, security could be something blocking for us. And then what is the result of all that? In the end, the way we're going to express our consent is option 1, clicking yes, option 2, clicking no. And then in the end, if I want something to be, clarified, I'm going to go to a DPA, or I'm going to write to Mike Schrems. That seems to be the only one to get some rights enforced really quite easily. So being informed concretely, there is a problem. Some surveys, and I shared also 3 only with you because I don't have time to do more. Let's focus on the blue one if you want to. 50% of users never read privacy policy. This is something from 2012. 40% seldom do so. 10% do so. European Commission released one that was even worse, and I didn't want to quote this one. Yes, we can have an explicit consent granted, but it's going to be an everlasting one. So if in red, if you have a look at the yellow arrow in the second one, if a unilateral modification is done, then maybe something is going to be changed. But my consent that I gave before is supposed to work out the same way. And for instance, the third arrow, focusing on Snowden revelation, may impact me and make me wish not to consent anymore. And then my need and my privacy choices are going to be modified, and I cannot do anything about that. So unambiguous also, I just made a kind of short way to state that maybe cookies and Internet of Things, it was stressed out before and really highlighted, I won't go this way. It can be unambiguous, but for instance, if I do click on, the pop-up for cookies, it's really explicit. It's really unambiguous, sorry. But do I really want to have those cookies on my computer? Those are the questions we should go through. And then I wanted to make a focus on a French decision released by the French Unfair Terms Commission. It was on November last year. It's really interesting because if you go through the decision, everything is unfair. Everything in the terms of it was on social networking contracts. So it was supposed to be too vague, non-specific, breaching contract because of unilateral modification, deceptive because it does not state clearly that mandatory provision of consumer law apply. Then there was a focus on the fact that imprecisely identifying documents in the agreement was part of the problem. When I've got 15 agreements to go through, I cannot consent really in a really informed way. Prohibition also was stated of the fact of saying that if I am a social network, I'm going to say, hey, this is a free service. Yeah, but no, I'm going to reuse your data. So they flagged somehow the fact that we call it free, because it is not indeed, because of further use of data. So the conclusion of the French Unfair Commission was adhesion contracts should not be a one-block waiver. And this is leading to question 3 really quickly. How can we reduce the gap between theory and practices? So maybe let's focus on the first column. We are supposed to have information that is systematic, intelligible, clear. We are supposed to read and assess. We are supposed, when we click yes, to consent with each single provision. And we are supposed to deem that in big data and Internet of Things, everything is going to be fine. So what I wanted to stress with you is that the issue might not be about, being too theoretical, too legal, between unambiguous and specific consent and legitimate interest, prior or not. Maybe the problem is about the fact that when we do consent, it's a take it or leave it option. There is no way to build upon, long-run monitoring, and there are some hidden purposes. So what could we do next? Then something that I call the forum, but it's not new. Working Party 29 said it, it was stated before, but this is just the way I wanted to sum it up. Multi-layered consent could be a solution regarding information, notices, choices, boxes. Being mobile-friendly, because we do use mobile a lot more than 10 years ago, and within 10 years it's going to be even worse. So conspicuous, intelligible, available information should be provided for. Meaningful, I'm going to go to this one on next slide, and modular, the right to withdraw, opt-out mechanisms, and potentially, as Julie said, dashboards. So maybe there is a way to be really simple on this issue. As a consumer, really, individually, I would be really happy to be providing a consent only on key issues, such as knowing whether I'm going to be profiled with the data, knowing whether commercial or marketing purposes are going to be targeted. And then it's supposed to be anonymized, but on big data analytics and IT research. So I would finalize with this last slide. I'm going through this one. What are the key objectives for Microsoft today regarding all those principles? So first and foremost, sure, complying with EU law. It seems a little bit dumb, I agree. But in this context of the draft regulation discussion, this is not that easy. This is thinking on our feet, what is going to be a DPIA, being ready. Being accountable and transparent, meaning we're going to tell you what we are going to further process with your data. About big data, sure, but about commercial marketing purposes. Then asking consent as a first step to take. This is the initial accountable step to take. This is not less and this is not more. And backing it as much as we can with a legitimate interest assessment, because we ask for consent, but it's not a waiver. It's just a way to process data, to inform you, but on our side, to assess risks and to make the best possible effort to grant you some privacy. Thank you.
Great. Thanks for that. It's actually interesting now, as we are going to be hearing from Finn about the consumer association. It's interesting, Marie-Charlotte, how you made that very good bridge between what Julie was talking about, deceptive practices and consumer protection, and in fact where we in Europe seem to be going as well, which is no imbalance in the consent. Consent is invalid if it is part of standard terms and conditions, and that's exactly where I think DAPIX is, the stuff that DAPIX is discussing, and of course what we're seeing in France. But what do consumers think about all of this?
Surprise, surprise. We are not too impressed with the terms of service that we see today. My name is Finn Myrstad. I'm from the Norwegian Consumer Council. I also work with the European Consumer Organization here in Brussels and cooperate quite closely with also those in the US. I'd like to kick off my intervention here with a little video. And mind you, it's in Danish. I'm aware you might not speak Danish. I don't really understand it, but it's subtitles. Read the subtitles, and I think this is done with a hidden camera, and it's just a minute long, but it illustrates my point a little bit in detail.
Det ser lækkert ud.
Så skal jeg lige bede om de sidste 5 sms'er, du har sendt.
Hvad for noget?
Mit telefonnummer? Nej, hvad skal jeg? Så vil jeg også have dit. Det skal I ikke.
Nej.
Nej, på min liste. Nej, jeg vil ikke have.
Jeg sendte det til min søster.
Ja, hvad er søsterens nummer?
Jeg vil da ikke udgive hendes telefonnummer til nogen. Det lover jeg dig, jeg ikke vil. Jeg udleverer ikke nogens uden af tilladelse.
Ja, så skal jeg lige høre, hvor du var i går kl. 8.
Så var jeg hjemme hos mine forældre.
Har du deres telefonnummer samtidig?
Ja, det får du heller ikke.
Hej, jeg går bare lige med jer.
Nå, okay.
Bare se, hvor I skal hen.
Nå, okay. Det er lidt mærkeligt, det her. Nå, men vi skal derover.
Ja, så er vi bare det.
Okay, thank you. I think you got the point. So basically, this is a hidden camera episode done by the Danish Consumer Council, where they basically ask questions from random terms of service of the most popular services that people use. And as you saw, when confronted with the same questions in real life, they felt that they were invasive, intrusive, and most of them preferred not to do it. And I think that's quite illustrative of the informed consent that we have today, and the sort of notice and consent, paradigm. And my point with this presentation will be to tell you we need to turn this model all around. So I agree with much of what's been said in the panel, but I do think we need to go much further because we cannot base consent or consumer protection and privacy based on this form of consent we have today. And also the point made by Microsoft, it would take a long time to read all the privacy policies that are out there. This is a study done, some of you might know this, it's a bit old study, Carnegie Mellon, assessed how long it would take, in theory, to read all the privacy policies and terms and conditions you would encounter during a day using digital services, going online, etc. They assessed it would take 25 days, and probably more, to read all the terms and conditions that you're supposed to every year. The opportunity cost, if every American were to do this, was $781 billion a year. So I don't think we want people to read these policies, and from what I've heard in panel today, I think we all agree that this is not a good way forward. Also, Julie mentioned President Obama, and he's doing some good things now, and there was a report to him done in, I think, in May last year from his council of advisors, and basically said this, that the framework for notice and consent is also becoming unworkable as a useful foundation for policy. So that's maybe something we need to take on board when we talk about the European privacy regulation. Only in some fantasy world do users actually read these notices and understand their implications before clicking. So I think we need to really change these terms if we actually expect people to understand them. And I actually don't think that's possible, and I'll explain why. So this is the outline of my short presentation. I'll give you a few examples from work that we have done in Norway, but also in Europe, on terms. Then I will talk briefly about the consequences, and then I'll outline a few of the things that I think needs to be done in order to remedy the situation. So, at the council, the Consumer Council, where I work, we decided last year to look at terms. We've had about a decade of work doing terms and conditions, and we wanted to continue. We've done filed complaints against Apple iTunes back in 2006, Facebook in 2010, Sony, PlayStation in 2011, and last year we filed another complaint based on this study. So what we decided, we wanted to go into this, into the discussions that have been going on now. How are these terms? And we decided we want to look at a very basic service, not too many complications, so we decided to look at cloud storage services. They're quite similar. You can store your files, your videos, etc. online. So in theory, you could compare them quite easily. Also, most of them are free, or you pay once you get up to a certain point. However, it was not as easy as we thought. 2 months later, 3 or 4 employees later, we managed to boil down 77 points of assessments to 11. So it said we spent quite a lot of time and resources trying to understand these terms. And I'm just going to show you a very brief summary of some of them. You can find this report on our website. And I'm just focusing on this privacy chapter of our assessment. And we saw that quite a few of them were breaching with what we expect to be consumer rights and privacy today. And the last point there, it says it's about content of your files. Can companies look at the content of your files, which is quite important when you talk about cloud storage services. Can people go into them? Can they copy them, etc.? So we actually put both Microsoft and Apple and Google in the doghouse and said, come on, what are you doing? You can look at their files. Clearly, we knew that some of these looking at the files are quite legitimate. I mean, you need to scan for viruses, for example. You might want to create a preview. And as Microsoft is doing, they are actually scanning automatically for child abuse photos. But it doesn't say in the terms. So in theory, anyone in the corporation could go and look at the files of anyone who uploaded their content there. And considering that some of these providers are providing services on multiple other arenas, you could put that together and you have quite a detailed profile of someone's life, in theory. The good news is, we did a review again last week, and let's see. This is what we found. So actually, now, a year later, both Microsoft and Apple have changed their terms. Microsoft actually invited us for a meeting, so we talked to them and explained why, they asked, what do we do? What have we done wrong? And we said, this is what we thought. And now it's changed. We also filed a complaint against Apple for breach of consumer law, and they also changed their terms after a few letters back and forth with their new iOS update. So what this tells me is that having terms can be useful for people like us. We can sit down and we can spend working hours on it and assess them on legal basis that people talked about, but it cannot be the ground for expecting people to know what they're saying yes to. We need a completely different approach because people don't have access to an IT guy, a lawyer, and so on when they make these decisions. So the second part I'd like to draw your attention to is third-party consent. Some of you might know this, but when you're on a social network, let's use Facebook as an example, you also do share information with third parties. And this is also where consent becomes very blurry. Because what happens is I just randomly checked the App Store. There's a court case currently going in Germany, if I'm not mistaken, by the German Consumer Council looking into this exact issue. They won in the first court level in Berlin, but the case is not decided. And basically what we're objecting to is, again, terms of third parties. And when you use this game, Fruit Ninja, randomly collected, it was what was suggested to me, so I don't know what that says about my habits online. But here you see, you basically share your information, your profile picture, that's fine, your gender, user ID, and your list of friends. Your friends never consented to you sharing their contact information. And we believe this is a breach of quite a few different laws. At least definitely we believe this to be unfair terms. And you could also say, where is this mandated in privacy law? I'm not a lawyer, so I'm sure there are many others here who can give me the exact details about that. So that's quite problematic. And also, these guys, Fruit Ninja, again, random example, they share information with third parties they cooperate with. I checked their terms. And so do most of them. So basically, users have no control over what is happening to the data. And my friends have no idea I share their data. And they have no way of contacting the third parties or Fruit Ninja to find out what happens to their data. So this is very, very borderline. And then I would like to move on to the third party where there's no consent. Julie described it quite well in her introduction, data brokering. Every time you visit a website, there are plenty of cookies, beacons, fingerprinting, lots of different techniques, trying to figure out who you are, what you're clicking, what you're watching, how long you're watching it, etc., etc., etc. This information is passed on, sold, collected with other types of information and used against you or for you. We don't really know. But what we are afraid of, we see more tendencies of that in the US, and I'm glad the FTC are looking into that. It's basically the whole data brokering industry using consumer data and negatively, possibly also discriminating weak groups. We've seen payday loans being targeted to consumers who are more likely to take up those loans. We can also see a scenario where people who don't give away data are discriminated. So you're basically having a race to the bottom. So this is something that we need, believe, should, and this is just an overview of the industry just in the US. And how do you expect consumers to necessarily contact all these people? So the initiative of Julie, I think, is laudable, but I still think that's far away from what is actually realistic to expect from a consumer. They don't even know these guys exist. So they're probably not going to visit the website, I'm afraid. I hope it works, but I've tried quite a few of those opt-out mechanisms online, and I still get loads of trackers on my web searches. So what's the consequence? People have been talking about chilling effect. People modify their activity online, and this is quite a serious impact. If people stop saying what they want, publishing what they want, and modifying their behavior online. And I think actually that's quite bad for industry as well, because they don't get true data. So I think there's an incentive for industry to stop being more transparent and do something about what's happening. And mistrust is created. People will use digital services less, and that's bad. So what could be done? I'll try to sum this up very quickly. Self-regulation is not an option. I don't think I'm going to go into that. Terms and conditions can be improved. As you've seen, we worked on it. It's possible. It's good grounds for people like us to work on, but they cannot be good enough alone. We need different levels of privacy. It needs to be different levels, not take it or leave it the way it is today. Yeah. Interoperability is super important, so you can move your stuff if you're unhappy with a provider. For example, Amazon, you can't move your books to another ebook provider. If you're unhappy with their terms, you're locked in. So this is super important in order to create competition and also give consumers the power to switch. Enforcement, FTC, good work. European data protection, European data protection authorities in general have a lot to do there. EU data protection regulation needs to be passed. Here I'd just like to comment very briefly on an issue on automated decision making and targeted profiling. What I heard the last time, this is more or less weakened in the current draft in the Council. This needs to be strengthened according to the European Parliament wishes. This is super important in order to avoid discrimination of the consumers. We need better cross-border legislation. Safe harbor isn't working for consumers. Either it needs to be fixed or we need to replace it with something else. Lots of people have talked about that. I won't go into details. At the end of the day, what we need is a new deal on data. Consumers need to get the power back. They need to control their own data. There are some interesting panels later tomorrow, I believe, that will look at different business models. This is interesting. I think consumers should have control of their data and then sell their data to data brokers if they want to. That way we can achieve real control, and there's a benefit for the consumer if they choose to share. Thank you.
Thank you, Finn, for your presentation, and thank you also to Julie, Marie-Charlotte, and Wojciech for their very interesting presentations, and of course, Bojana, for your introduction to this subject, which really helped us to get into it. I think if we had more time, we could analyze this topic, go into it much deeper. We've seen it now from different perspectives, but at the end, we come to the same conclusions. We have approximately a quarter of an hour for a debate, and we will launch this debate by a question I will ask, maybe second one if we have time, and afterwards I will give the floor to the audience to ask questions. I would like to ask a question which links Europe and the US. As the European Parliament, within its work regarding the new data protection regulation, focuses on lifecycle data protection management, I would like to know if the panelists agree on this approach as far as regards user control over their data, and I would especially like to know if this is also a consideration from the US perspective, and I would ask Julie to comment on this.
So life cycle management is often a term that is used from a company perspective. That is, they should be thinking about data from when they first touch it to when they're going to dispose of it. And we very much focus on that at the Federal Trade Commission, particularly when we're looking at data security issues. I do think thinking about life cycle management from a consumer's perspective, and I want to be clear, Finn, you're not the only one here who thinks about the consumer's perspective. I spent 25 years at the consumer protection at the state level in the United States, and all I did was prosecute companies for violating consumer protection rights, not only in privacy, but with respect to all sorts of things. So you're not the only consumer protection advocate here. So when you think about it, though, from a consumer's perspective, it's you got to think about how to do this in an innovative and creative way. We can't expect moms and dads who are, trying to get their kids dressed in the morning, trying to get them off to school, trying to deal with them on play dates and stuff like that on the weekends, maybe trying to spend a few moments with them just to themselves. Also to be thinking about, gosh, how do I want to manage my data day to day in terms of its entire life cycle? That's why we in the United States, and we particularly at the Federal Trade Commission, are really trying to focus companies on doing this on their own. That is, not doing the things that consumers would expect them to be doing. That is, and how does this relate to actual life cycle management? Delete information when you don't need it anymore. I mean, one of the keys to thinking about how to avoid security breaches is data minimization. If you've had a transaction with the consumer, you don't need to hold on to their credit card information and the exact transaction information forever, because if you do hold on to it forever and it's not de-identified in a robust way, it could, and almost every company is subject to some kind of a data breach. That information could be part of the data breach, and it could harm consumers and harm the company's reputation. So data minimization, de-identification, these are all very important elements of lifecycle management that aren't part of the consumer's choice, because the consumer expects these things to be happening. And that's why we then focus on the expectations of the consumer and the context of the transaction. Give consumers appropriate choices when you're dealing with data in a way that is outside of the context, that is not part of the ordinary transaction, because consumers are going to expect that their data is treated appropriately in the context where they're reaching out to someone online, they want to buy something. They're going to understand that their credit card information or their address is going to be shared with the service provider so that product can be delivered to them. That's understood and expected. There shouldn't be choices about that. But how that information is then dealt with going forward, yes, that should be handled in an appropriately sensitive way. But where I think consumers' choices really need to come into play is with respect to these third-party collectors, the data brokers and others and ad networks who are gathering information and consumers know nothing about it. That's the area where I feel we really need to spend some time and attention in terms of giving consumers appropriate choice. And also with respect to mobile, when geo is being collected, geolocation, contacts are being collected, and where is that going? Even if a consumer gives a choice about that, are they also giving the choice that it should be shared? Likely not. Consumers need to know, and they need to be told in a creative way. And so, Finn, I just want to be real clear about what my suggestion is with the portals, because I think you got it wrong, and I want to make sure that everybody else understands. No one's doing what I'm suggesting now. They're really not. The data brokers are not providing the kind of immersive portal, single portal, where consumers can go to find out how they're being profiled, how the data is being used, and what their choices are, and giving them choices about it in the first instance. And going to your point about payday lenders and how data can be used, this is really sort of a tricky question. I think consumers need to know that they're being profiled if they are unbanked or they're low income. Now, that data can be used in a very harmful way for consumers. Exactly as you said, they could be profiled for payday loans, for other types of uses of that data that could really harm them. But the very same bits of information can be used in a way that can actually benefit them and bring them into the banking community. If a bank wants to offer a new product, an introductory credit card to those who are unbanked, they might be able to find those consumers more easily with this kind of a profiling. So the real trick is, how do we tell consumers when the information is going to be used for appropriate uses that they might want to take place versus uses that they don't want to take place? And I'll just use one more example in terms of how data can be used in good ways and bad ways. Think about health information and research. You know, if you go around talking to consumers and doctors and providers in the way that I do, consumers will say, especially if they're like the parent of a kid who has a really bad disease, or they themselves have a bad disease, they will say, of course I want my data used by people who are going to find a cure. Are you crazy? Are you not using my data to find a cure? They are very often aggressive about wanting their data to be used in proactive ways so that cures can be found. And then there are people who might not have a sort of an incurable disease, or a disease that it hasn't been solved yet, but a manageable disease, but yet one that, in other words, a disease that can be managed, but yet one that can lead to stigmatizing. So whether it's HIV positive, whether it's diabetes, whether it's a mental health condition, all of which can often be managed, yet they will say, no, I don't want my data to be shared. So how do you manage this issue? That is, using data in creative, appropriate ways to solve problems on the one hand, and yet also making sure that consumers aren't victimized on the other. I think when you're dealing with sensitive information, we do need to give much more information to consumers and allow them to choose, allow them to understand how it's being used and to control it. So that means health, it means information about kids, it means geolocation, there's a few others, financial. I think these are the areas where we really need to provide more control to consumers, because it's sensitive information, and that's when they need to know what's happening.
Thank you, Julie. It's good to hear the American perspective on these issues. I am a little concerned about, or I am concerned about the time too, and the data brokers, which is something that is not really that known for users here in Europe. So I feel that there's an evolution towards transparency and information, away from the explicit consent, especially as regards the data brokers. And before passing the floor to the audience, I would like to see if there are any of the European panelists that would like to comment on this evolution. Marie-Charlotte?
I don't feel highly concerned by this one, just because, as you might have guessed from the presentations that I shared with you, there is a clear step taken. Thank you. There is a clear step taken. You know, Microsoft is kind of a traditional company. It's almost 40 years old. The business model is based on devices and services, providing a service you paid for. So this is not the same business model than, you know, pure players, as we call them, or other, you know, data brokers. So I feel that maybe there is a line that is kind of beginning to be drawn today between you know, the companies saying, okay, it's for free. You know, remember the Unfair Clauses Commission in France decision, and then the companies that will sure further use data, but first telling you so, second, you know, trying to find out a way to either having some better quality of service, or maybe providing you the specific information that if you do agree and you really are willing to have a personalized advertisement, you can go, you know, through those profiling, marketing, commercial further uses. But the thing that I maybe could highlight for as a conclusion on my side is that it's definitely not the business model Microsoft shows.
Thank you, Marie-Charlotte. I think we have time for one short question. There's, here in the third row, in the middle. Perhaps you can ask several questions quickly. The one on the right could ask a second question afterwards.
Thank you. In the world of data protection, where the consumer can't, won't, or just doesn't care about its data, and the companies that don't care about the data protection because they just want as much data as possible because there's a lot of money involved. How can the data protection authorities, either the American version or the European version, have the balance between, on the one hand, not stopping innovation on the company side, and on the other one, protect the consumer interest?
Thank you. Perhaps you can take a second question just on the right, behind in the fourth or fifth row.
Well, I have a small comment or also a question. If we compare with the car you buy, the producer says that you need to change the engine oil after 10,000 kilometers. Can you object or not consent to this? So the question is there any digital services that is linked with data processing that is minimum, you cannot object, and this means that you cannot consent or consent. And what is the second next stage when data are processed outside from this minimum, where you have to give consent, and how and who will be this institution who will separate these two things?
Thank you. Who would like to answer this question? Perhaps Julie or Wojciech?
I will try to answer to the first question. Well, you actually gave the subject for 3 days conference, how to make this balance. And there's absolutely no 1 minute answer to this question. But actually this is what the, for example, data protection authorities all over Europe, no matter if they are in Europe or if they are in other jurisdiction, have to fight with. I don't agree with you in 100% that the people don't care about the privacy and they don't care about the data, how it's processed, as you said at the beginning. That's of course a generalization, and that's something which I don't agree. And I think also this short film that was presented by our Norwegian colleague have shown that we are not aware of the fact that we are giving the data. We are not aware of the fact that something flows out, but this is not rather like giving up and giving everything about myself to the others.
Yeah, I completely agree with everything that Wojciech just said, especially, you know, if you look at the rise of privacy-enhancing services and technologies that consumers are really seeking out, whether it's Whisper, Snapchat, or whether it's other forms of trying to protect their information. This is an issue, what we're talking about is an issue that consumers are not aware. When they become aware, they can be concerned. You know, building in, though, an appropriate balancing test, again, to the first question, in the United States, our test, if we're not in a sector-specific law, you know, you're not dealing with children, you're not dealing with health, you're not dealing with financial, you're not dealing with credit reporting, in all those areas we have very specific, detailed laws about how the data can be used. Outside of those areas, we're dealing with a general law that talks about unfair and deceptive acts and practices are not allowed. And these are actually robust, flexible standards that are very good because they can be applied in new technologies and new areas that nobody thought about when these laws were enacted. But the unfairness test has built into it a balancing test. So in order for me to go after a company for an unfair act, I have to show that there was harm to a consumer, and this is not just financial harm. It can be use of sensitive information in inappropriate ways. It can be collection of sensitive information in inappropriate ways. The second prong of the test, it's got to be unavoidable by consumers. And the third prong is that there is no offsetting benefits to consumers or competition. So built into the actual test that we have to go to court and prove is a balancing test. And I actually think that that's good because it makes sure that we're focused on practices that are indeed harmful to consumers.
Thank you, Julie. Finn, would you like to answer the second question before Bojana concludes?
Okay. No, very basically, I think where we draw the lines as consumer representative is basically there's some things a service needs to have in order to function, right? Google Maps wouldn't be Google Maps without geolocation potentially. I mean, you can't turn it off and it still works, but it can't tell you where you are. The same for like an IP phone app. It needs access to your contact if you're actually going to call your friends. So, you know, there are legitimate uses of data, and for sure we recognize that, but we think that many apps and many digital services are taking way too much. But it's going to be like we're going to look into each specific service before we can say this and that, and then we'll say unfair terms, or we'll use consumer legislation, we'll use data protection legislation, depending on what we think is the best thing to do. I hope that answered your question, but yeah.
And I think we have to stop because we do have another panel that is going to conclude today's day. I hope you've enjoyed this discussion. In fact, you know, we talked about convergence in data privacy a lot in previous several panels, and it seems to me that there's been a lot of convergence, some divergence, but a lot of convergence among our panelists. There is certainly emerging trend in looking at privacy and consumer protection in a similar way, and certainly using both to combat perhaps what we see a problem today, both here in Europe, but very much in the US. The unfairness of the FTC, well, it's an incredibly powerful weapon, and you know, people who don't like it are actually disputing this with the FTC, and which is why they fear it. But we do have fair processing in Europe, and we just have to remember, we plus have all these data privacy principles, and Julie, you reminded us, you also looking at other things rather than notice and choice to make sure that processing is not deceptive and it is fair. And I think that's an incredibly important message for those who are tweeting up there. That's what Julie said. Legitimate interest, Wojciech has fabulously explained this. Please be courageous, use it, think about it, because it's accountable, because it balances the rights of individuals with legitimate interests, and it takes into account something that Finn has also talked about, which is, and you, Julie, impact on individuals. And you know that the Center is very strongly pushing on understanding the privacy harms and risks and impact on individual, and that's us, responsible organizations, have to do. Marie-Charlotte, your 5 M's, I think we all have to remember them, so I hope you will send us the presentation. We certainly liked a lot of the solutions that you were proposing. So thank you very much with that, and with this, we have to vacate this stage. Thank you, the panelists.